The Institute
for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your usually bi-weekly podcast on the Federal Courts of Appeal. This week, we traveled to Chapel Hill to record a special live edition at the UNC School of Law at the invitation of the UNC chapter of the Federalist Society. The episode features special guest Chris Brook of the ACLU of North Carolina, as well as IJ's very own Justin Pearson. We had some technical difficulties with Justin's mic in the beginning, but bear with us, it gets sorted out a few minutes in. One further note, the episode also features the final appearance of Sheldon Gilbert on the podcast. Sheldon has now left his post as the director of IJ's Center for Judicial Engagement. We'll miss him dearly, and if any of our listeners want his gig, please do go to the opportunities section of ij.org to look at the job description.
Thank you. And again, welcome to a live edition of the Short Circuit podcast, the slightly irreverent podcast dedicated to covering interesting things happening in the federal courts of appeals. Today, we've got a really fun program. We're going to preview what's on the docket for the 2018 term. As Adam mentioned, the Supreme Court's term starts today, October 1st. It's like opening day of baseball season. We're very excited about it. We have some great guests who are joining us today. The first guest here with us is Justin Pearson. Justin is a colleague of mine at the Institute for Justice. He's the managing director of our Florida office, and he oversees the Institute's national economic liberty efforts. Justin has litigated in a host of areas, including civil asset forfeiture and economic liberty. But most important about Justin's career is that he has appeared multiple times in Dairy Herd Management magazine. And if you have not yet renewed your subscription to Dairy Herd Management magazine, this is your reminder. So thank you, Justin, for being here with us.
No problem. I should also point out I was the centerfold.
Yeah, he was the centerfold in Dairy Herd Management magazine. Even better. And next, we've got Chris Brook. Chris Brook is the legal director of ACLU of North Carolina and an alum of UNC Chapel Hill. Chris manages a whole host of litigation issues at ACLU, and he's going to talk about some of those issues today. And Chris has actually taught in this very room at UNC before terrible things happened and you got kicked out into a different room, right, down in the basement?
The facade of the building, y'all might have heard about this, at some point subsided and moved away from the rest of the building. And so I got slotted down into a cubby hole in the basement that ruined my seating chart.
Now, this is the part where none of you feel any sympathy for the professor. Well, we're very excited to be here today. Just to give you a little sense for the format, we're going to organize today's podcast into kind of three different parts. Part one, we're going to have a haiku quiz show where I am going to read a haiku that I have drafted, and our panelists here are going to see if they can correctly guess what case it is, and I will arbitrarily award points, not based on whether they get it right, but based on my sheer caprice. So whatever I feel like, I will be awarding points arbitrarily to these gentlemen. So in part two, each of these gentlemen, Justin and Chris, will be talking about a particular case on the Supreme Court's docket, or a case that could end up on the Supreme Court's docket in the near future. And then in the third part of the program, we're going to take questions from everyone in the audience. Now, I have a challenge. We want substantive questions about the Supreme Court's term, but I have some Short Circuit branded Bluetooth headphones that I'm going to give away to students that can ask questions that stump Justin or Chris. So this is your reward for coming up with a good Supreme Court question that neither Justin nor Chris can answer. And with that, let's go ahead and get started. I thought about bringing like a little bell to ring whenever they get something right, but we don't have a budget for that. We spend it on the Bluetooth headphones. So we are going to get started, and I'm going to start with Chris, and I'm going to read the first haiku. And we'll see if Chris can get it right. If Chris doesn't get it right, it'll bounce to Justin for an opportunity to guess the case.
This is so terrifying. This is like easily the worst part of my week.
All right, Chris. Louisiana has no dusky gopher frogs, Paper Co. argues.
That's Weyerhaeuser, right?
Oh, ding, 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 ding. That's right. That's the Weyerhaeuser case. This is an Endangered Species Act case. And the Endangered Species Act, the question is whether the Endangered Species Act prohibits designations of private land as unoccupied critical habitat. So the private land in question doesn't have any dusky gopher frogs on it, but maybe someday it possibly could have a dusky gopher frog on it. So can it be regulated like critical habitat? Okay. That's an easy one. I'm not going to give that one to you, Justin. All right. So I'm going to give Chris 17 points to start off with for getting the first one right. Now we're going to go to Justin. Justin, trucker class action is stalled by arbitration. Can court restart it? I'm going to dock you 2 points already for not having an answer yet.
Oh, I forget.
I was going to give you the takings clause, but I knew you'd know it. All right, Chris, do you want an opportunity to take this one?
No.
All right, this is a case that's near and dear to my heart. It's a Federal Arbitration Act case, and I know that's why you guys came today is to hear about Federal Arbitration Act. But the issue in this case is whether a dispute over if Federal Arbitration Act applies must be resolved in the arbitration, or can it be resolved by the court itself? So it's a question of who decides that threshold question of the applicability of the Federal Arbitration Act Section 1 exemption. And the name of the case is New Prime Inc. versus Oliveda. New Prime Inc. versus Oliveda. All right, I'm going to give the easy case that Justin would have gotten to Chris. All right, Chris. Land might have old graves, so town creates right-of-way. Where must owner sue?
I don't know.
Oh, did I mention you lost 80 points for not getting it last time? But because Chris was so humble and saying he doesn't know, I give him 7 points. All right, Justin, would you like to answer that one?
That's Nick versus Scott.
Nick versus Scott. Has everybody heard about this case?
Obviously not.
This town passes this law that says, like, look, Pennsylvania is filled with these old cemeteries, some of which we don't even know where they're at. And if your property, private property, has a cemetery, then we're going to create a right-of-way for people to go onto your property whenever they want to go visit it. The owner of a particular piece of property that might or might not have graves on it sued, and the question in this case is essentially, where does she get to sue first? Does she have to sue in state court and wait until she loses there, or can she go into federal court? It's an old question that's been percolating. It was decided by the Supreme Court years ago in this case called Williamson County, and is back, and there might be an opportunity to revisit that case. All right, next one. Let's give this to, you don't get any points because you know the case and probably worked on it at some point, I'm sure. Justin, so nothing for you. Okay, the next case. This is another Armed Career Criminal Act case. Justin, this is for you. Victim resists, but burglar doesn't use violence. Violent felony? Question mark.
That's Stokeling.
Stokeling, that's right. Do you know the issue in Stokeling?
It's whether even a modicum of resistance or forcing you to overcome that is enough to meet the definition of a violent crime.
You know, I was hoping he didn't know the actual issue in the case so I could deduct more points, but I'm going to give you 7 points for that. All right. Let's go to the next one. This one's a fun name. All right, Chris. Can tribe dodge taxes for off-reservation biz? Check the old treaty.
Cougar Den.
That's right. This is the Cougar Den case. This case involves a business that's organized under the Yakima tribe laws, and it operates off the reservation, but it brings petroleum and other gas into the reservation, and the state wants to tax it. The tribe says, no, you can't tax us. You don't have the rights under an 1855 treaty, and that's the issue in the case. This is a fun one, Justin. And as soon as I figure out whether or not you get this right, I'll decide how many points Chris gets. All right. You're a class member. If you ever used Google, but no cash for you.
This is Ted Frank's case.
Do you know the name of the case?
Frank for Scouse.
Dang it. All right. I will give you, but you knew Ted Frank, so it doesn't count. So I'll give you 2 points for knowing the name of the case. This is Frank versus Gauss. So this is one of these cases about class action settlements. In this case, some consumers sued Google and said, hey, you violated our privacy rights by the way that you collected information on us. When the company and the class settled the case for oodles of money, none of the money essentially went to the class members at all, the people actually injured by the privacy violation. Instead, the money went to a mix of the lawyers' who brought the lawsuit and these private third-party entities under this doctrine called cypre, which basically means kind of the next best use. If you can't give the money to the person that you want to give it to or should go to, then what's the next best use? And the money instead went to these organizations that were essentially, under the petitioner's theory, controlled by either Google or the plaintiff's lawyers, right? So the argument is the plaintiff's lawyers and Google were essentially getting all of the money for the class action settlement, and the argument is that this class action settlement is then invalid under the class action rules. All right.
Did I get any points for that?
I told you got 2 points for knowing it, but I deduct 15 points because you were smarmy about knowing the answer. All right. If anybody's keeping track, Justin is down by approximately 17,000 points. All right, Chris, here's one for you. This is the best case about iPhones on the docket. You pay lots more for apps from the Apple App Store. Can you sue Apple?
I recognize that I'm obviously being treated very kindly here. I think this is Apple versus Pepper.
All right. I kind of gave away one of the parties with Apple, but you got the Pepper right. Justin would have said it was Apple versus Salt, and he would have been totally wrong. And because I think that's what his answer would have been, I deduct 15 more points from Justin, and Chris gets 30,000 points. All right. Chris is now in the lead. And Chris, we're going to give one last haiku, and you're going to get the last haiku, Chris. Non-delegation died after sick chicken case. But wait, maybe not.
Justin, you want to help me out here?
It's Gundy.
Gundy?
Yes.
That is correct, Justin. Unfortunately, it had not yet gone to you yet. So you were deducted 15 points for violating the rules. And Chris, because he was so gracious in handing the question to Justin, gets, let's say, 40,000 points. All right. Justin's is clearly in the lead at this point with somewhere around 1 million points. In this case, Gundy versus United States is a case that arises under the Federal Sex Offender Registration and Notification Act. But the case really isn't so much about sex offenders or whether they should register, but about a constitutional doctrine known as non-delegation. This doctrine is derived from the vesting clauses of the Constitution. So if you open your pocket Constitution, which I'm sure you have with you, and you open to the very first part of the Constitution, page 1, Article 1, Section 1 says, all legislative powers herein granted shall be vested in a Congress of the United States. Note that it says all legislative powers, not some, not many, not most, but all powers are vested in Congress. So the theory of the non-delegation doctrine is Congress can't give away or delegate away its legislative power to an executive agency. Well, of course, in the modern administrative state, this happens all the time, and that's in no small part because the Supreme Court has not found a violation of the vesting clause or the non-delegation doctrine in over 80 years since the Schechter poultry case, which is unfairly nicknamed the sick chicken case. And if you want to understand why that's a terrible nickname for the case, you can check out the Institute for Justice's amicus brief on the case, which tells you the great story of the Schechter brothers and the Schechter poultry case. All right, so that's the end for our haiku section, unless somebody in the audience has a haiku that they want to throw at our panelists and see if they can answer it. Anybody a big fan of drafting haikus on the spot? All right. We're going to go to the second part of our program. We're going to ask Justin and Chris to each talk about an important case that they have been involved in or been watching closely or carefully that either is at the Supreme Court or could be at the Supreme Court soon. Let's go with Chris first. Chris, what case did you pick?
Yeah, I selected a case called American Legion versus AHA, which is American Humanist Association. And it has not yet been granted for Supreme Court review, which is in and of itself sort of a surprise. I want to talk about this one I think we're going to talk about for about 5 minutes or so, because it comes out of the Fourth Circuit where we're at. It's a case out of Maryland, just to the east of Washington, D.C. It's not our case at ACLU of North Carolina, but we had an Establishment Clause case that was moving through the Fourth Circuit a little bit earlier than that. So we were watching this case with a lot of interest. So I think it's an interesting subject matter, but I also think it's sort of a canary in the coal mine in regards to what the Supreme Court is, how aggressive the conservative wing of the Supreme Court's going to be in the coming years. So I think it's interesting to look at it from that perspective. So this case involves a 40-foot tall Latin cross that was established in memory of soldiers from Prince George's County in Maryland who died in World War I. There's a much smaller commemorative plaque that's nearby the cross. It's displayed in a very busy traffic circle in Bladensburg, Maryland. There was a groundbreaking for it in 1919, and in 1925 it was dedicated with a Christian service on site. It's been maintained by the government since 1961 with around $217,000 either expended or dedicated to maintenance of the cross and the surrounding area. It's been the site for numerous veterans events, but also religious events throughout the years. And there's some other war memorial and monuments in the general vicinity, but they're kind of far-flung on occasion. So the Fourth Circuit, in a relatively liberal panel a pretty liberal panel of the Fourth Circuit, found that this violated the Establishment Clause, and they applied the Lemon test, which some of y'all might be familiar with sort of a gloss from a case called Van Orden, and Lemon looks at purpose of the display in this instance, the effect of it, and whether it fosters an excessive entanglement between the government and religion. And Van Orden is a decision from Justice Breyer that decided two religious display cases on the same day in opposite directions. Van Orden, in the Van Orden case, finding that there was not a violation of the Establishment Clause, looking at sort of the circumstances surrounding the monument's placement, its physical setting, and the length of time that the monument went unchallenged. So in this instance, the panel, in a 2-to-1 panel decision at the Fourth Circuit, said that it violated both the advancement and the entanglement clause prongs of the Lemon test, recognizing sort of the obvious that a cross is the preeminent symbol of Christianity, and that its exceptionally prominent nature very much overwhelmed and outweighed the secular components surrounding it. Also said that the government ownership and maintenance of the cross and the surrounding area, as well as the size, history, and context, sending a message conflating being American with being Christian, resulted in an excessive entanglement between the church and state. At that point, Maryland, defending this display, sought what's called en banc review, where you try to have the entire circuit sit and hear your case. This was the three-judge panel, again, as I mentioned, was very liberal. I thought that they were going to grant en banc review and probably reverse the panel decision, perhaps on Van Orden grounds, because there's some similarities there. At that point, the Fourth Circuit had 14 judges on it. It now has 15 judges on it, but the Fourth Circuit declined en banc review 8-6. And it was largely, ideological split on the court, but there actually, for example, Judge Duncan, who's from North Carolina, who was appointed to the bench by President George W. Bush, voted against en banc review. A couple of democratically appointed judges voted for en banc review. So it's an interesting split. And so now that is pending at the Supreme Court. The petition for Supreme Court review not only seeks reversal of the Fourth Circuit's decision, but some further clarity about what rule governs these sorts of monuments in the Establishment Clause context, and very firmly pushes for a case called Town of Greece, which is actually a legislative prayer case from 2014 that sort of lays out a coercion or whether these sorts of monuments have historically been a part of the nation's sort of test for judging these sorts of monuments. It was heard at the Long Conference and distributed for the Long Conference. Again, I sort of thought that there would be a cert grant that would perhaps have come out of the Long Conference last week. They did not take any action at that Long Conference. They only granted, if memory serves, 5 cases. I think that has to be something of a reflection of the fact that we don't know what's going to happen with Judge Kavanaugh's nomination. This is certainly a decision that could split 4-4, so the Supreme Court might be looking, at least in the short term, to avoid taking some of these cases that would result in 4-4 splits. I think that there are a lot of different options that you could see come about with this case. You could see the Supreme Court very aggressively impose a new rule in regards to what governs the Establishment Clause along the lines of Town of Greece, as the petitioner suggests. They could narrowly reverse the Fourth Circuit on Van Orden grounds based on Breyer's concurrence, or they could choose not to take the case and say, listen, either we're going to have an 8-justice court for some period of time, so we need to take a breath here, or even if Judge Kavanaugh does get on the Supreme Court, that we want to just avoid some of these hot button topics for some period of time because, being blunt, he's been so damaged by the confirmation hearing.
Well, so backing up procedurally, if you could kind of explain what you mean by the Long Conference. So that terminology might not be familiar to everybody in the room or our listeners. And if you could tell us what that is and what the significance of that is.
Yeah, and you know it better than I do, so you can correct me where I'm wrong here, but right before a Supreme Court term starts, they review all the cert petitions, my understanding, that have built up over the course of the summer. That's that's about 20% of the year. So you would typically, and my understanding is you have typically seen around 20% of the cert grants. So about 20% of the cases that they're going to hear over a term, which might be around 20 or somewhere less than 20 cases, would be granted at that Long Conference. This year they granted 5. I think it's hard to, and there are obviously some interesting.
And they didn't deny that many either.
That's right. And they're obviously, as we discussed in the haiku portion of this segment of the show, that there's some interesting, exciting ones that are out there, but they're not. When you come off of a term that featured Masterpiece Cake Shop, that featured the Trump travel ban, et cetera, there were tons of blockbusters in the last term. They're not similar blockbusters right now.
I disagree.
Set up, well,
that arbitration case is awesome. Yes, that's right. So that's great. Thank you for explaining the Long Conference. Well, before we get to Justin talking about his case, does anybody have any questions about the Bladensburg Cross case? Yes, it looks like we've got a couple questions. And you're going to say your question, then I'm going to repeat it so that we capture it. So we're going to go, yes. Okay, so the question is, isn't there another case where the court said that a cross isn't always a religious symbol like the German Iron Cross? How is this case distinguished?
Well, and people up here on the panel might disagree with me in regards to this and might disagree with what the Fourth Circuit said in regards to this, but that's essentially one of the arguments that was made in front of the Fourth Circuit, and said that, listen, the cross in particular is associated with war dead out of World War I, so that there is a secular meaning to it as in addition to a religious meaning. And the Fourth Circuit essentially said, listen, the reason that it's associated with death is because it's associated with Jesus's crucifixion. So it has even that sort of secular reason at bottom is really a religious reason. And Judge Wynn, who's also from North Carolina, from Eastern North Carolina, actually wrote a concurrence from the denial to the denial of en banc review, where he amplified on an idea that was in Judge Thacker's opinion, which was essentially like, it's offensive in a way to try to scrub what is so obviously a religious symbol of its religious meaning. And it's degrading to religion, and this is why we have a separation of church and state, is to avoid that sort of degradation where there are arguments that are essentially like, oh, a cross is not a religious symbol. Now, whether you agree with that opinion, it's definitely something that was in a footnote in Thacker's panel decision, and it's very much amplified in Wynn's concurrence.
Thank you. I think we had one more question back there. The question is the recent Supreme Court case called Trinity Lutheran about grants to pay for playground, asphalt, stuff like that, whatever.
I mean, it was
how applicable that case is to this?
It's a different context. It's a different factual context. I think it tells you a couple of things. Trinity Lutheran, in that instance, it was funds that were being used for a playground. Bad facts can make bad law on occasions. And that's, you're essentially folks who are arguing against that. We're arguing against playground resurfacing. You never necessarily are excited about arguing against playground resurfacing, right?
Do you think that this case has something of the same dynamic, arguing to tear down a war memorial?
Yeah, no, I think that
and
certainly that's something that the cert petition leans into, the idea, and certainly some of the denial, the dissents from denial of en banc review. Judge Wilkinson, who actually is somewhat idiosyncratic on Establishment Clause cases, said, we should let these war dead rest in peace, relatively sort of swinging for the rafters in that sort of commentary. I think the thing that you can tell, even though it's different contexts, is that there are two. Sotomayor and Ginsburg dissented in Trinity Lutheran. They are obviously the most progressive in regard to Establishment Clause cases. If memory serves, Gorsuch and Thomas filed a concurrence in Trinity Lutheran. They are obviously at the other end of the spectrum. I think that Kagan and Breyer occupy a more moderate liberal position on that, and then Alito and Roberts I think are sort of conservative, but perhaps not as much so, in particular Roberts, as Gorsuch and Thomas would be. But especially if Judge Kavanaugh is ultimately confirmed to the court, you'd be looking at a situation where a lot of these cases are going to be decided by the chief.
Yeah, and
go ahead.
If I may, just so everyone's clear on the facts of Trinity Lutheran, because I do think it is arguably distinguishable. That was a case where you had a state funding program to provide funds to all schools, including private schools, and the question was whether you could have a carve-out that just prevented religious schools from participating as opposed to other private schools. And so when you have that type of statewide program where there's just a specific carve-out based on religion, I think that does raise some different concerns than this case.
Do you think this case taps into kind of some of the broader questions that we're having as a society about, I don't recall the Judge Wilkinson's line, but let the war dead rest in peace. There's a debate even happening here at UNC Chapel Hill campus recently about memorials for the war dead, right? Does this tap into that in terms of why this case has gotten so much attention? Is it part of these broader questions about collective memory and how we what message the government says about things that have happened in the past, or do you see this as totally different?
It's as a double Tar Heel, the Silent Sam situation is different to an extent, but it obviously it somewhat turns on your perspective in regards to this matter. And there are obviously people who view this in the cross and also view Silent Sam as sort of a passive and benign acknowledgement of things that have happened, right? There are other people who they are much more active objects in both instances, and they send a message about who belongs in particular spaces and certain people not belonging in particular spaces, and it's the government sending that message in those instances, predominantly to racial minorities, but there's overlap between religious minorities as well.
And do you think that's why the challenge to the cross, you mentioned, one of the facts that you focused on is not just the size of it, but the location. It's a heavy traffic area. So a lot of people, it's not just something that's out, in the middle of the Mojave Desert, but it's something that people see on a regular basis.
Yeah, and that raises some questions about who is the reasonable observer here, and that's something where there's been some churn at the Fourth Circuit, because most people's interaction with this traffic circle is just going to be driving by it. And you're going to see a 40-foot tall cross and not be able to contextualize it in any way, shape, or form, and know that there's a plaque that honors the 49 who died from Prince George's County in World War I. You might not know that there's a September 11th memorial path nearby. So and this is something that then Judge Gorsuch wrote about on the 10th Circuit about who is the reasonable observer. How much information does the reasonable observer have?
Do you think most people driving by even know that it's like on government property or that it's a government cross?
I think that's a fair question as well. It's right in the middle of a traffic circle, so I think that it's easier to know that the government probably plays some role in maintaining that traffic circle than to necessarily know when it was put up and that its association with World War I. Put another way, I think it's easier to glean that the government's doing something there than the association to World War I.
Thank you. That's very interesting. All right, we're going to move on to our next case. Justin Pearson is going to, I think, talk about a case that our organization, the Institute for Justice, is handling on the Supreme Court's docket this term. Can you tell us the name of the case and what it's about?
Absolutely. So the case I'd like to talk about is Timms versus Indiana. As Sheldon mentioned, that's an IJ case. Our colleagues will be arguing it on the merits at the Supreme Court in a couple months. And I think it's a fascinating case for two reasons. First, the question presented is interesting. And second, the case arises in a controversial context. So for the first point, the question presented is whether the Eighth Amendment's excessive fines clause is incorporated against the states under the 14th Amendment. As hopefully many of you know, most of the rights listed in the Bill of Rights have been incorporated against the states by now through the 14th Amendment. But there are a few that haven't, or in this case, at least where the incorporation is unclear. The Eighth Amendment has been incorporated in other cases, but those cases didn't deal with fines. And so it was unclear whether, at least to the Indiana Supreme Court, whether incorporation applied here. And so now we're going to find out from the Supreme Court. But the reason why I'm really fired up about this case is because it involves civil forfeiture. And so I'm curious, please, by show of hands, how many people here have heard of civil forfeiture? Yeah, not criminal forfeiture, civil forfeiture. Yeah, civil forfeiture is something that, and I'm glad just for the people listening to the podcast, about half the room raised their hands, which is heartening to me because not that long ago people hadn't heard of civil forfeiture, and they should have. It is an outrage. Unlike criminal forfeiture, civil forfeiture is when the police sue your property without necessarily arresting you or convicting anyone of anything.
Can you back up? Police sue your property?
That's right.
Okay, explain that, because
Absolutely.
That sounds weird to a lot of people who are listening.
Right. So if the police suspect that your property is naughty, they can sue your property and keep it for themselves, which gives them a tremendous incentive to be suspicious of everything. And then you have to hire a lawyer and go to court in the civil litigation context to try to get your property back, even though the average forfeiture involves money or property that is worth far less than the cost of hiring a lawyer to go try to get it back. It is a horribly abused system. It should not exist. The overwhelming majority of civil forfeitures involve situations where no one was ever convicted of anything.
Or even charged with anything or accused of anything.
Exactly. I mean, it's ridiculous. And so IJ has litigated a bunch of these cases representing people who have never been arrested in their lives, but the police took their property and wouldn't give it back. And each one of those cases is outrageous. You can find them all on our website, ij.org. This case is actually unusual. Timms, the Supreme Court case, is a bit unusual in that it's one of the rare cases where someone was actually convicted of something, but it's still outrageous in its own right.
But they didn't use criminal forfeiture to get the car, right?
No, they did not. So our client is a gentleman named Tyson Timms, and he has struggled with addiction. He developed opioid addiction when he had ankle surgery. That became meth addiction, and he kicked it for a while and was clean for a while. But then when his dad passed away, he was distraught, and he had a relapse. During this relapse, he found himself entangled in an undercover drug sting where basically he engaged in very low-level drug activity to feed his addiction. He was involved in up to 3 transactions that involved between $300 and $400 total. Like this is not a hardened criminal. This is not a drug kingpin. This is a low-level drug addict. And in fairness to the courts in Indiana, the criminal court recognized this. He was a first-time offender, so they didn't throw the book at him. Instead, they ordered him to get drug treatment, which was the right approach. They didn't send him to prison. They put him on house arrest, ordered him to get drug treatment, and of course, he's on probation, and he had to pay some fines and fees. That was the right approach. But the police wanted Tyson's SUV. You see, when his dad passed away, his dad left him money, and he used $42,000 of that money to turn around and buy a brand new SUV. and the police wanted it for themselves. Because under civil forfeiture, they're allowed to keep the property money they seize for themselves, for their own agencies, for their own departments, which causes them to go around chasing money instead of chasing bad guys.
And what's the usual standard of proof to get your property back when the police use civil forfeiture?
Well, so it all depends on what state you're in. If you're in federal court, it's the preponderance standard. Thankfully, thanks to the work done by IJ and other groups, some states have changed their standard for the better.
But you basically have to prove that your property is innocent, right? So it's
right.
You have the burden to prove that your property never did anything wrong.
Right, and even over and above the fact that the burdens are switched, you have to usually pay a lawyer more than your property is worth, which most reasonable people won't do. And the police know this, and so they take advantage of it. And so anyway, so even though Tyson's SUV had nothing to do with the drug trade, it was just the car he took to drive to and from these really small drug transactions. The police said that was enough. Since that happened to be the car he drove to and from those small drug deals, they wanted his $42,000 SUV that was brand new for themselves. And they filed a lawsuit in civil court suing his SUV.
And so when you see these weird case captions, so I'll just read some examples for you. This is what they're about if it's a case that sounds really weird. So United States versus article consisting of 50,000 cardboard boxes, more or less, each containing one pair of clacker balls, right? That's the name, that's the caption of the case. Or another one that I really like, Nebraska versus 1970 two-door sedan Rambler Gremlin. Can
I give you my favorite?
What's your favorite?
My personal favorite is the United States versus one solid gold object in the shape of a rooster.
Yeah.
True case.
So the fiction is that the property has done something wrong, right? And so the government is suing the property itself. That's kind of the legal fiction around civil asset forfeiture.
And so now, unlike most forfeitures, there was actually enough value at stake here where it was worthwhile to Tyson to fight back. And so he goes to civil court. And among the other arguments his attorney asserts, they assert that this is unconstitutionally excessive. And the civil trial judge agrees with them. And the trial court's logic was sound. What the trial court explained was that, listen, setting aside for the fact that Tyson's a first-time offender and he's in this diversion program, let's say for the sake of argument, the state had absolutely thrown the book at him and piled on every possible penalty and fee and fine you can think of. Even that total amount would be less than 1/4 of the value of his new SUV. And so using that logic, the trial court found that it was unconstitutionally excessive. The police really wanted the SUV, so they appealed. The Indiana Court of Appeals affirmed the trial court's ruling. But again, the police really wanted that brand new SUV, so they appealed again to the Indiana Supreme Court, who did something really weird. They said, well, that may all be true, except we're not sure that the excessive fines clause of the Eighth Amendment has actually been incorporated against the states. The incorporation cases involving the Eighth Amendment didn't deal expressly with fines, and we're not going to incorporate it against ourselves, even though other states have reached different rulings. We're going to reverse. We're going to say that the police can keep the SUV unless you can get the Supreme Court to grant cert. That's when IJ got involved. My colleagues filed a cert petition. The Supreme Court granted it. It's going to be argued in a couple months. Now, this is an Eighth Amendment argument, right? So this wouldn't get rid of civil forfeiture right away. But civil forfeiture is a horrible thing. It should not exist. And anytime you can even chip away at a horrible thing, that's something that should be celebrated. And so I'm really excited to see how this goes.
It's also pretty interesting that this is, you're calling it a civil forfeiture case. I see it through the lens of the 14th Amendment, which turns 150 this year. It's the 150th anniversary of the 14th Amendment. And the 14th Amendment is the amendment that kind of radically altered the structure of our Constitution and the relationship between individuals and the government. It provided those constitutional protections for us against states. And this will be the first opportunity for many of the sitting justices to talk about how they interpret the 14th Amendment and how they approach incorporation. And I think that makes it a really interesting one to watch just for that reason alone.
Well, and it does. And along those lines, you always have the question of, do you incorporate using due process of law or the Privileges or Immunities Clause? We know what Justice Thomas thinks from his McDonald concurrence. We'll see whether Justice Gorsuch perhaps might agree with him. Even still, I think it's more likely that a plurality will go with due process as opposed to the PRI clause, but that breakdown should be interesting.
All right. Let's take some questions. Any questions about the Timms case? And then if there after questions about Timms, we'll see if anybody has any other questions. Yes. So the question is, let's say that you have a loan on the car, Can the police, does that affect the value of the car for you? And can the police still take it if it's partially not owned by you?
Right. So if there's a loan on the car, then the lender has priority, which means if the loan exceeds the value of the car, the police won't be interested because civil forfeiture is not actually about fighting crime. It's about taking stuff that the police can keep. But if there's a loan that's less than the value of the car, then the police will keep the difference. So basically the car will get sold.
There's also this category of civil forfeiture cases called innocent owner cases, right? And these are cases where, Bob and Jane didn't do anything wrong, but their 16-year-old dumb kid took the car, had a drug in it, was pulled over, and the police, say, we're going to arrest your kid and we're going to take your car. And then Bob and Jane say, wait a second, we didn't do anything with our car. Or there's a famous case that IJ handled about a motel, the Caswell Motel, and police found some illicit activities that some people who are, visiting the motel were engaged in.
Less than any of the neighboring hotels or motels.
Yeah, right. So it was the least criminal hotel around. But because some criminal activity was taking place in the hotel, the police used civil forfeiture to take the entire hotel, right? And the owners said, we didn't know about this. We didn't have anything to do with this. It can't be right that you can take our entire hotel because somebody in one room was engaged in, certain type of activity. And we actually won that case.
Yeah, there was actually a trial on that one, and IJ was able to win, which was cool.
All right. Any questions more broadly about the Supreme Court term for our panelists? Yes. So the question is, in Gundy versus United States, the non-delegation case, does the fact that the delegation in question is criminal in nature, that is, failure to register under the Sex Offender Registration and Notification Act is a crime, and the Attorney General, who enforces the law, the prosecutor gets to determine the scope of the crime and gets to enforce the violations of the crime itself, right? So does that make a difference in terms of the non-delegation analysis? Any thoughts from Justin? Or
I don't know that it does. It's an interesting point. I mean, I can see why you would say that because, of course, you have the rule of lenity that often comes up in criminal cases, and so it often does make a difference. But when you're talking about the non-delegation doctrine, I don't think it does. I don't think that's what the analysis is going to turn on. Now,
there is a case from the 10th Circuit by a little-known judge named Judge Gorsuch, where he wrote a dissent in a challenge to the exact same statute, SORNA, and the same provision of the statute, and he dissented from a rehearing denial, and so the Supreme Court ought to take the case up. But he said that the fact that it is a delegation of determining the scope of criminal law does make a difference, right? And so at least one person has said, and there are a lot of other folks who make the same argument, that it ought to make a difference that what's being delegated is the authority to define what the scope of a crime is to the very people who will then enforce the criminal laws, and that's particularly dangerous, right? Thomas Paine always warned against, the avidity to punish is such that human nature will reach terrible outcomes and do terrible things even with the best of intentions because of our avidity to punish, right? So there is an argument by at least one member of the court that that's the case.
And that could be extremely interesting when you consider the fact that most regulations have a criminal component or a criminal penalty. And so where do you draw that line?
Right. So there are roughly a 1990 study estimated that there are at least 300,000 federal regulatory crimes, right? These are things that are a crime because a regulatory agency said so, compared to about 4,000 crimes, federal crimes that are on the books because Congress said, right? So a lot of the job of deciding what is and isn't a crime from a federal perspective has been outsourced to federal agencies, and that's why you get all sorts of weird stuff. If you look at the Institute for Justice's amicus brief, we give you lots of crazy examples. So, for example, it is a federal crime to sell soy spaghetti that isn't a particular shape, right? Some types of noodles have to be, ribbon shaped. If they're egg noodles, they can't be other types of shape, or it's a crime. If you see one of those little warnings on like a toy where it's like a triangle with an exclamation mark in it, I don't know if you've ever seen one of those. If that triangle is not an equilateral triangle, then it's a crime. So do not use an isosceles triangle because that's a federal regulatory crime, right? So
if I could,
yeah, go ahead.
My personal favorite, because of my own biases and my own cases I've worked on, is it's a crime to call skim milk if the only ingredient is skim milk.
That's right. Justin has a case pending right now on that issue. Is that in the Fourth Circuit as well?
That's in the Middle District of Pennsylvania, so it'll eventually go to the Third.
Your client's in Maryland, but the case is in. Got it.
Right. Yeah.
Right. All right. Any other? Do we have any time for one more question? One more question. Yes. Okay. So the question is, what might we see from the court in terms of voting rights and redistricting?
Well, I think that, again, it's pretty hard to predict as we sit here today because we don't know exactly what's going to happen later this week, and we don't know what's going to happen with the vacancy that's currently on the court. I think that it seems pretty clear that the 8 current members of the court have sorted themselves equally into the 4 quote-unquote liberals who believe that these the partisan redistricting cases, for example, when we have here in North Carolina, that they are justiciable, that there are standards that could be applied here and could be applied in other circumstances. The North Carolina case that found that the legislature engaged in an unconstitutional partisan gerrymander to benefit Republicans in the state has not actually been heard by the Supreme Court. It's just got sent back to the 3-judge panel here in North Carolina after the Wisconsin and Maryland cases got kicked on standing grounds. It did seem like an oral argument in that case that there was maybe some consensus that, like, just straight up announcing that you are doing a partisan gerrymandering, which is what David Lewis, the Republican leader of redistricting efforts, did here in North Carolina, would be beyond the pale. But it does seem like there are 4 liberals who believe there can be standards applied here and that there is an element where it's too far. Seem to be the 4 conservative justices that are currently on the court have some real questions about whether this is justiciable. So you could have a situation where there's a 4-4 split. I think if Judge Kavanaugh were confirmed to the court, which again we don't know what's going to happen there, it's much more easy. It's much easier to slot him with the conservatives on this sort of matter than with the liberals, which I think would result in them deciding 5-4 narrowly that these sorts of partisan gerrymandering disputes just simply don't lend themselves to manageable judicial standards.
And North Carolina, as you suggested, has been kind of ground zero for a lot of these cases, right?
And for a long time.
All right. Well, I want to thank our panelists today. Can we give a round of applause? Thank you. We also want to thank UNC Law School for hosting us and the UNC Federalist Society chapter for hosting us. And this has been another edition of Short Circuit Live, where Justin loses yet again.